Sorry, guys, we're just testing one thing. Okay, share sound. Okay,
Oh, perfect.
okay,
Okay.
we figured it out. All right. Once my voice starts echoing, well, is that overstimulating for you, Christina? Okay, guys, we're gonna get started. Who left? It's a couple people just left. Is that Celine? What are you laughing at? Why are you giggling? Oh. Okay, guys, we're gonna get started. For my online people, can you guys hear me? Hopefully. If anyone online can give me like a yes that you guys can hear us. A little delayed. No? Okay. Perfect. Just need like one. Okay. I'm gonna put you beside my little friend.
Good. Oh,
You're shorter than me. Okay, guys, we're going to get started. We have Bita, Lisi here, which I think this is your third time with us, right?
Yes.
From Stonegate Legal. We always love having you in. We're gonna be talking about our favorite topic, which is tenants, which is a great topic now because we're doing double the amount of leases than we probably ever have ever. And I know you guys are probably experiencing that too. I lied about the topic. I think I said we were talking about listing and selling tenanted properties, which is okay because we actually did that, I think, last year.
Yes.
So we do have a recording on that if you guys want to go back, and I'll send it actually as well. But we actually are doing non-payment, right?
Correct. Non-payment of rent and evictions.
Non-payment of rent and evictions, which actually is a really good topic right now anyways, because I think we're seeing that a lot with tenants not paying, or I'm seeing it a lot when the landlord wants to sell and then all of a sudden the tenant's like, screw it, I'm not paying anymore. So there's a whole bunch of stuff. Sorry, I get like distracted. And so we're gonna be talking all about that. So we're gonna do a quick presentation. Lots of you guys typically have questions. Lots of you have questions unrelated to the topic as well, which you do usually answer, so it's fine. So if you guys do have questions online, put them in the chat. We'll answer them after the session. And then all my guys that are here, you guys can also ask your questions as well. But we're gonna get started. So thanks for coming on out.
Thank you for having me. I think we're gonna get started with a video first.
Yes, I'll help you with that one. Hopefully this works. Actually, wait, I didn't click a search button. Oh, I do have it. Okay. Here we go. Everyone can see it. Or I press play. Okay. This is your grandfather?
It's my father-in-law.
This is your father-in-law.
Turned 90.
All right, 90-year-old father-in-law.
He's not acting. He's playing himself.
All right, here we go. Let me move the.
You don't want to pay me, huh? Okay, I'll fix you.
I got this. I don't know who you are. I don't know what you want. If you're looking for money, I can tell you my landlord has no money to give you. But what he does have is a team. A team with a very particular set of skills. Skills that we have acquired over a very long career. Skills that make us a nightmare for tenants like you. If you move now, that'll be the end of it. We will not look for you. We will not pursue you. But if you don't, we will look for you. We will find you. And we will evict you.
Good luck.
Hello, I'm Bita Lisi.
And I'm Rob Lisi, and I want to welcome you to Stonegate Legal Services.
Our team provides legal support to realtors, landlords, and investors throughout the province of Ontario, mainly in the areas of non-payment of rent, late payment of rent, lots of cash for key settlements, landlords wanting to occupy their tenanted properties, new purchasers wanting to occupy their newly purchased tenanted properties, and we also defend landlords against tenant applications.
But Bita, don't forget, we also offer services in garnishment and evictions. Great, wonderful. I'm glad everything worked out. Great. You have a wonderful day. This is the favorite part of my job, is when I have happy clients. And I always tell clients, don't judge us on our winners, but judge us on our losers, because we have so few of them.
If you're sick and tired of chasing your tenants and you're worried about the delays of the landlord and tenant board, you don't have to go through this alone.
Feel free to visit our website and book a free discovery call today.
Combination of Taken, Wolf of Wall Street.
Okay.
Wait, can we just send that to tenants?
You can.
This is my paralegal. Don't screw with me. Okay, let's get to this present.
Go Rob to evict the Toronto Maple Leafs.
Now you're pushing it.
I don't think I am.
I don't use PowerPoint very often.
Oh, just click.
Just click it and play. Is that good? Okay.
Oh, perfect.
And then I have my little mouse, or I think you can do.
Perfect.
Okay, I'm gonna let you take over.
Thank you. So good morning, everyone. Thank you so much for taking time out of your day to come and learn about best legal practices in owning and operating rental properties. My name is Bita Lisi. I promise you, you're gonna love this content. So head over to our social media, like us, follow us on Facebook and Instagram. We always tend to provide updates with what's happening in the realm of landlords and tenants. And if you ever come across a matter where you require some clarity, perhaps you have a question, perhaps there's an uncertainty, email is by far the best method of communication with myself directly, because I'm always on training sessions like this one. However, if you do call our office, likely you may not get a hold of me because I'm here. You may get a hold of one of my team members, all of whom will be happy to assist you. So for the purpose of this presentation, everything we discuss is for information only. Nothing is to be taken as legal advice. If I can kindly ask that you hold all of your questions to the very end, I promise you we will open up the floor for a Q&A, and you can ask me anything that's landlord and tenant related. So I'll tell you a little bit about our team. Well, I believe that video summed it up. Our team, we provide legal support to realtors and their landlord and investor clients. Now, we are a landlord-based firm, and what that means is that we only provide support to landlords. The reason why is because tenants have access to free legal resources, like free community service legal clinic, free duty counsel, free legal aid. Whereas we found over the past 20 years that realtors and landlords, they don't have a support system. And every time you need some support, or you have a question, a 1-minute question, a 5-minute question, every time you pick up the phone to call someone, they ask for money. They say, well, I need $250 for 15 minutes of having a discussion with you. So what we've done is we've built that, not asking for money, not charging a fee. We've built that support system for you guys as realtors and your landlord and investor clients. So let's get started, everyone. Let's talk about non-payment of rent. Now, this is not a session on how to fill out a non-payment of rent notice. It's not a session on how to do it yourself, how to serve it, none of that. On the contrary, guys, is to let you know, do not do this yourself, because really you're not licensed to do so. You hold a license, a professional license in the province of Ontario to trade real estate, not to perform a legal service. And guys, when you're acting on behalf of your clients, remember your clients rely on the information that you provide them, because you've already built that foundation of trust. So again, the N4 notice comes with strong consequences and requirements. And we're going to talk about these requirements and consequences. But before we do that, Before we do that, I want to talk about the reasons why agents should never get involved with legal proceedings. So first and foremost, I guess the biggest one is you're not licensed to do so. You're not licensed by the Law Society of Ontario. And if you're not licensed to provide a service, by providing that service, you are going against the law. Not only the Law Society rules, but TRESA. Now that leads me to number 2. When you're acting outside of your scope of work, your errors and omissions insurance does not cover you. Doesn't cover you. You're not licensed to do something. You do it, and then you expect your safety net, being your insurance, to protect you, and it doesn't. So if your insurance doesn't protect you, you open up yourselves to liability because you're not familiar with the requirements or consequences. And every one of you here is a representative of Century 21 Percy Fulton. So what does that mean? Well, that means whatever you all do out there, good or bad, falls on the brokerage. So not only do you open up yourselves to liability, you open up the brokerage to liability. And guys, I mentioned to you that we provide support to agents, and I have several conversations with agents every day. And there are agents who say to me, they call me and they say, you were right. I'm just leaving my broker's office and he had to let me go, or she had to let me go because I've become too much of a liability. So we don't want that to happen to any of you guys here. That's why I'm saying, guys, this session is for general information only. You need to know what the N4 process looks like. Not you need to do it for your clients. You need to know the basics. So we're going to talk about the basics of the N4. But let's first talk about what is an N4 notice. Well, the N4 notice, the notice number 4 for landlords, is a notice for non-payment of rent. And it can be served at the earliest, the day after the termination date. Now, once it is served, it tells the tenant, hey, tenant, you have a couple of options. Option number 1, you pay all of the arrears in order to void the notice. Not half of the arrears, not partial payments, all of the arrears to stay. You pay to stay. Option number 2, you move out by the termination date. Or you do nothing, and if you do nothing, it is up to the landlord to commence a legal proceeding to evict you and get an order from the board to collect and evict the tenant. Well, what else do you need to know? Well, if the tenant moves out, if the tenant opts to move out by the termination date, their tenancy comes to an end the date that they move out. I want you to remember that because we're going to be talking about breaking leases throughout the session. But you need to know that in accordance with Section 37(2) of the Act, if a tenant moves out of the unit by the termination date, that date is the last date of their tenancy. Now, what that also means is that their obligation to pay the rent also comes to an end when they move out, when they no longer exercise any sort of control over the rental unit. So that's basically what the N4 says in a nutshell. It's a pay to stay. If you avoid the order, you can stay. Well, let's talk about other things that realtors need to know, because there are times where tenants are in possession of a unit and they owe money, and then there are times where the tenant vacates and they owe money. So this part of the session, we're going to talk about when the tenant exercises control over the unit. So the tenant, in order for an N4 to be served, and then an L1, landlord's application number 1, to be filed with the board, the tenant must be in possession of the unit. So let's define what is possession. Well, the Ontario Court of Appeal defined possession, a tenant is in possession of a rental unit where they exercise some form of control over the unit. They have the keys, they have their belongings, they live there, their parents live there with them, they have children who are residing in the rental unit. That is exercising some sort of control over the rental unit. Now, it's very common that if a tenant stops paying the rent, they also stop paying for utilities. If you don't have the money to pay rent, you're not going to pay utilities, right? Well, Here's what you need to know about the non-payment of rent notice. It is a non-payment of rent notice, meaning that if you tack on utilities on this type of notice, on the application filed with the landlord and tenant board, your notice is void. Because every issue brought in front of the board has its own process. Non-payment of rent, non-payment of rent. Unpaid utilities, unpaid utilities. Personal use, personal use. The board can only decide on matters, individual matters, brought in front of them. I want to spend a couple minutes talking about guarantor agreements. For those of you who know me, you know that I'm not a fan of guarantor agreements. I'm not a fan of co-signer agreements. And I'll tell you why. Number one, a co-signer agreement or a guarantor agreement must be a separate agreement. You can't draft your Ontario standard lease and then put Caitlin Fulton and then in brackets guarantor and say, here, Caitlin, you're now guarantor. That doesn't make her a guarantor. Those two brackets with the word guarantor in between them doesn't make her a guarantor. A guarantor agreement needs to be a separate agreement. It's a contract, and it needs to meticulously outline a couple of things. Number one, who's in charge or who is responsible for payment in the event that the tenant stops paying the rent? Who's responsible for payment in the event that there are damages to the property? Now, the reason I say that you should never include a guarantor with brackets on a lease agreement, because number one, that's improper. And number two, let's say, for example, Caitlin says, I'm going to be a guarantor for my sister. And she signs as a guarantor the 1-year lease. Even aside from the lease, she signs a guarantor agreement, a legit guarantor agreement. Well, you know how that 1-year lease comes to an end and the tenancy continues on a month-to-month? Contracts like the guarantor agreement cannot be an indefinite contract. There needs to be an end date. Does that mean that Caitlin is a guarantor for her sister forever? No, because if her sister defaults in month 16, when the tenancy is a month-to-month, and the landlord pursues it through the landlord and tenant board, going after her sister, and then through small claims court, going after her on the tort of contract law, Caitlin has a position that there's no more guarantor contract because the lease is a month-to-month tenancy. So I'm not a fan of guarantor agreements for that purpose. And secondly, in order for guarantor agreements to be enforced, they have to go through the small claims court. Because like I said, it's the tort of contract law. The landlord and tenant board does not have jurisdiction to hear contract matters. They can only hear disputes between landlords and tenants. And last but not least, guys, errors. Errors, no matter how minor. You forget to put the basement apartment, you forget to put the postal code in the city, you make an error on the rent period, you miscalculated the rent period, calculations are not clear, it poses a confusion. Any error, no matter how minor, what's going to happen at the board is going to result in a dismissal. So again, another reason why I say, guys, as agents, don't get involved, because you don't really know how to complete these notices. And when it gets to the board 4 to 6 months after, it's too late. I promise you, your clients are going to point the finger at you. There's no way your client is going to say, it's okay, Caitlin, I got you. No. What the client is going to say is, you knew better. You're a realtor. There's an imbalance of power. I'm owed thousands of dollars, and I'm going after you. It happens all the time. So you want to just be careful. But I want to talk about errors because I said errors, no matter how minor, will result in a dismissal. The most common error is made here on the rent period calculation on the second page of the N4 notice. And it's either the calculation or the actual rent period date. So guys, a rent period, a monthly rent period runs from the first of the month, so January 1st, to the last day of the month, January 31st. February 1st to February 28th, March 1st, March 31st, April 1st, April 30th, not January 1st to February 1st. And yes, that is a minor error. Everything else is the same, but you just put from the first to the first. But the board doesn't view that as a minor error. Legal documents like the N4 must be meticulously drafted. They must be error-free. Any error, even like that, it gets the matter tossed. The board, I'll tell you right now, for those of you who've experienced the landlord and tenant board, the board doesn't care if the tenant owes $50,000, $70,000, $100,000. They don't care. That's not relevant. What is owed is not relevant. There's not a list of exceptions. A legal proceeding must be followed properly. So we want to make sure that your notices are error-free. I also want to talk about service. So one thing I love about the real estate industry is that the industry has really evolved with technology. For those veteran agents, we also, you all used to be glued to your fax machines, used to come in and pick up your faxes, right? For those of you who remember that. But times have changed. We all have smartphones. We're sending and receiving agreements of purchase and sale via email. Your clients are signing using their fingers and e-signature tools. It's great. But the wheels of justice spin very, very slowly. And that means that landlords must serve their tenants in accordance with the rules of procedure in the following ways: by handing the document to a tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox where mail is usually delivered, sliding it under the door or through a mail slot, via fax or via mail. But guys, it's not as simple as what I've outlined here, because there are rules and procedures and requirements related to service. The first rule is, if mail is being used as an acceptable method of service, additional days must be added to the date of termination. That will make your N4 notice a 14 plus a minimum of, 5 or 10 days notice. If you miss that by 1 day, what happens? Your matter gets tossed. The other thing is, you'll notice that email is not on here. I want to take a moment and talk about email. The reason why email is not on here, not that it's not an acceptable method of service, but because I like to stick to the old school methods. And let me tell you why. For an email to be an acceptable method of service, the two-part test must be satisfied. Here's a two-part test. The first part of that test is that something must exist in writing, that the parties agree to send and receive notices of the landlord and tenant board via email. That's Section 3 of your Ontario Standard Lease. That's easy peasy, right? Here's the tricky part. The tricky part is the second part of that test, which says at the hearing, the landlord must prove to the board that the contents of that email came to the attention of the tenant or were acknowledged by the tenant. Read receipts, not acceptable, because I don't know if Caitlin got that email. Maybe she had a child who was playing on her phone and that email came through and the kid swiped to the left or swiped to the right, whatever. On a balance of probabilities, let's say, for example, I sent Caitlin a notice for non-payment of rent. You owe me $25,000. I say, "Dear Caitlin, please see attached notice for non-payment. Please acknowledge receipt." On a balance of probabilities, what is likely going to happen here? Is it likely that she's going to say, "Oh, confirm receipt"? No. Likely what's going to happen here is she's going to delete my email, pretend that she never got it. She's not going to show up at the hearing. And that's it. Because she knows that if the second part of that test is not satisfied, the matter won't get heard. It buys her additional time, which we don't want. But often I get asked, how does the board know, or how will the board know how the document was served? Well, this is how they know, via a certificate of service. A certificate of service is also, AKA an affidavit of service, how the document was served, who served it, when it was served, the method of service, the date it was served. And then it's filed with the landlord and tenant board. And when it's filed with the board, the tenant also has options here as well, because when it gets filed with the landlord and tenant board, it gets put in a holding cell. I'm going to call it a holding cell, in queue to be scheduled 4 to 6 months thereafter. So what happens to the tenant? Can the tenant void the notice? Do they have opportunities to pay and stay? Absolutely. Section 74 of the Act says that if a tenant has the means to pay, if they do pay, it voids an eviction. But they have four major opportunities to pay. They can pay all of the arrears by the termination date. They can pay all of the arrears by the hearing date. They can pay all of the arrears after the hearing date. Or they can pay all of the arrears before the sheriff comes to knock on their door to evict them. So I put 4 opportunities to pay. Really, they have to pay all of the arrears from the date that the N4 was served up until the date that the sheriff arrives, which right now, the entire process, if everything goes smoothly, can take up to 8 months. But what's the probability of a tenant paying all of the arrears? It's not likely, because we find that sometimes when they fall behind 1 or 2 months, it's very difficult for them to catch up. But that doesn't mean when you go to the landlord and tenant board, you're going to get an eviction order. You don't know what's going to happen at the landlord and tenant board. And I want to talk about the LTB process because this is, I'm going to call it dark waters, the unknown grounds. When an application is filed with the landlord and tenant board, it takes about 4 to 6 months to receive a notice of hearing. Sometimes it can take 2 months, 3 months. Sometimes it could take 7 months, 8 months. But on average, I like to manage expectations at the 4 to 6 month period. And when the board issues a notice of hearing, this is what the notice of hearing looks like. As of August 2020, the landlord and tenant board started holding online, virtual, and telephone hearings for landlord applications. Now, guys, anyone can attend a hearing. If you wanted to attend a hearing, just shoot me an email. I'll send you a link and you can log in and observe.
Really?
Absolutely. Send me an email and I'll send you some links.
Every day.
Every day. So every day. So there are actually 2 hearing blocks.
Brilliant.
The one is from 9 to 12 and another one is from 1 to 4. And there are non-payment of rent hearing blocks. There are bad faith application hearing blocks. There are spirit of an N12 hearing blocks, N12s, N13s, all types of hearings.
Is it fun watching?
Yeah, like
It depends.
if we just played it in the background at the office.
You can, because that's what I do. I play it in the background because I'll tell you why, because our team, we are a high volume office. So our team is in hearings every day. And I like to observe my team to see how they can do better and critically criticize. I don't want to say criticize because I don't like to criticize, but I like to constructive criticism. Exactly. But if you are a party to the application, you must attend the hearing, right? Doesn't matter if you're not the landlord, if you are as a realtor, if you're listed as a party, you must attend the hearing. If you don't attend the hearing, things may not go the way you anticipated. Now, at a non-payment of rent hearing, remember I said it's dark waters. You don't know what's going to happen. Landlords should never go into a hearing room with the mindset that I'm going to get an eviction, because that's not guaranteed. You have zero influence on the outcome. In fact, at a non-payment of rent hearing, parties are encouraged to work together. And here's where I always say, as a realtor, as a landlord, you have to look at the landlord and tenant board like a business, because that's exactly what their role is. Their role is to generate funds for the province. They don't care about your tenant. They don't care about you, landlord. Their role is to line the pockets of the province. So they are not going to automatically take this person and throw them out on the street, because that's essentially what you're asking for when you say evict this person. And when you go into a non-payment of rent hearing, there's a moderator, so somebody who takes attendance, and that moderator will ask you, are you open to mediation? And guys, the answer to that question is a yes. It's a yes or no question. Nobody cares how you feel. Nobody wants to hear an explanation. It's a yes or no. And that answer to that question should always be yes, Because in mediation, you'll meet with a board certified mediator and the tenant. Parties have to agree to mediation. And in mediation, that mediator's role is to bring the parties together so that there's a meeting of the minds. You're not always going to get 100% of what you want. It doesn't work that way, even when you're negotiating a purchase and sale for your clients. But you might get 50% of what you want. You might get 70% of what you want. But if you go in front of the landlord and tenant board, if you go in front of that board member, it's he who's deciding. It's whatever the big guy decides. You have zero influence. And though you maybe owe $30,000, $40,000, $50,000, there could be a tenant that says, I'm a single mother. I have 3 children. I'm on a fixed income. I'm on ODSP. I can't move, whatever the case is. And then he may decide, well, let's give her a payment plan. Let's not evict her. And we want to talk about relief from eviction as well, in accordance with Section 83 of the Act, where the tenant has the opportunity to persuade the board, please don't evict me, either deny or delay an eviction. For many reasons. I mentioned single mother, I don't have a job, I'm on ODSP, so forth and so on. And then guys, remember, you have no influence. So it's up to the adjudicator to decide the fate. But in addition to that, tenants have the opportunity to raise issues in accordance with Section 82 of the Act. And Section 82 of the Act basically is what tenants rely on, kind of like to say, this is the reasons why I didn't pay. And if they're going to rely on these reasons, perhaps the landlord didn't maintain the property. Perhaps the roof is caving in and the little kid can't sleep in their bedroom for whatever reason. And if tenants are going to rely on Section 82 of the Act, this is the chart that they're going to have to submit to the board and to the landlord at least 5 days before the hearing. Now, guys, if you see where the cursor is, it says describe the issue. So the roof leaks when it rains, when they inform the landlord, when did the issue start, when they inform the landlord, what did the landlord do? Has the issue been resolved? And what do they want the board to do? And obviously, if they're relying on these issues, Section 82 issues, they want a discount or an abatement of their rent. Now, when a tenant submits this, we now have to defend it. This is what the landlord did when they found out that the roof was leaking. Here are the pictures. The tenant had full use of the property. They could have slept in another room. There's 4 other bedrooms. Let's move on. The board, after hearing everybody's issues and everybody's complaints, the board doesn't render a decision right away. What they do, because your matter is not the only matter that's heard on that day, there's usually 40, 50, 60 people that are waiting for a matter to be heard in the same time block. The board will say, I will send out my decision and reasons for my decision in an order. This is what an order looks like. The original copy of this order can be taken to the enforcement office of the sheriff to book a date and a time for an eviction. Evictions don't happen overnight. Depending on where you are, it could take 3 weeks, it could take 4 weeks, it could take 8 weeks. I know that Peel right now is scheduling us between 16 weeks to 20 weeks. That's 4 months. 4 months on top of going through this process for an eviction. Now, guys, eviction orders expire. We had a landlord, we had a landlord who went through an eviction process. He was owed, I think, something like $18,000. And what he did, the tenant said, I can't get a truck, but if you allow me to spend the night, I will move tomorrow. So he was evicted by the sheriff. Landlord said, no problem, I'll let you back in. He let him back in, and guess who's still there? The tenant. When you evict, don't allow them back in. Why would you do that? We just went through a 6-month process to evict. So now we have to start the process over again. So eviction orders do expire. But in the event that you file for eviction, you or your locksmith or your property manager or your realtor will meet the enforcement officer, the sheriff, at the property. When a eviction is being carried out, it usually takes 10 to 15 minutes. It's very quick. The enforcement officer arrives, they knock on the door, they identify themselves, and then they post a notice of vacant possession on the front door. Remember, a tenancy comes to an end when the landlord gets possession of the property back. That's what the notice of vacant possession is for. What happens is the landlord, just hold your questions. The landlord will then be allowed to go into the property, secure the property, make sure the back door is locked, make sure the windows are locked, make sure the faucets are closed, make sure that there's no issues with the bathroom. We had an eviction a couple weeks ago where the tenant knew that they were being evicted, and what they did, they, the plug for the bathtub, they plugged the bathtub and they pooped and peed in the bathtub.
Wow.
And it was terrible. It was terrible. And that was kind of like to stick it to the landlord. But anything can happen at an eviction. Remember, these people are being thrown out of their home, which they didn't pay for. So at the eviction, possession is then given back to the landlord. And when possession is given back to the landlord, the tenant is no longer there. So what happens with their stuff? Well, tenants have 72 hours to connect with the landlord to provide supervised access to the property. So here's how it's going to go down. So I'm the tenant. I'm going to call Caitlin. I'm going to say, Caitlin, I have a moving truck tomorrow between 12 and 4. I need access to the property. She is going to say, no problem. I'm only letting you in when I see the U-Haul truck and your buddies. She'll meet me at the property. She'll bring her folding chair and her phone, and she will sit right outside the door. She's not going to open the door and say, hey, I'll see you in 4 hours. No, she's going to sit right outside the door. Maybe she's going to bring a friend with her in case things go down. And then I'm going to move my stuff out. Never, ever open the door and say, I'll be back. Those former tenants left in the unit by themselves, unsupervised, is never a good idea, ever. Now, once the tenant, after the 72 hours, whatever's left behind, now the landlord can do whatever they want with it. But what happens with the order? Well, now the tenant has been evicted, but she still owes $25,000. Well, now I can enforce garnishment. And enforcement can be via garnishment of the wages, which goes back to the start of the tenancy or prior to the start of tenancy when you're pre-qualifying. Because when things go down and you're at this stage and you want your money back, if that person is not working, you can't do anything. So collections go back to garnishment of wages or garnishment of their bank account. Let's talk about that. I mentioned that you can only garnish employed earnings. If they're on ODSP, if they're on pension, if they're on Ontario Works, none of these benefits are garnishable. You cannot touch any of this. But let's say the tenant was working. You can really garnish 20% per paycheck until all of the arrears have been paid. This is through the small claims court. So you get an order from the landlord and tenant board. Now you have to enforce it through the small claims court. And hopefully, if you're owed money and you started the garnishment process, hopefully that tenant doesn't lose their job. Hopefully they don't pass away. Hopefully they don't move out of the country. Because if any of that happens, or can't collect from someone who's passed away, but if they move jobs, you're going to have to restart the garnishment process. So that's garnishment. We want to make sure that they are working. Just hold questions. We talked about the N4 when the tenant exercises control over the property. But let's say, for example, Caitlin's my tenant and she moved out. She moved out and I was late in serving the N4, or I let things slide for a while. And then she's gone. How do I find her? Well, it would no longer be the N4 process, because the N4 process, one of the requirements is that the tenant must be in possession. If Caitlin has moved out, I now have to find her. How do I do that? Well, I have to hire a private investigator to find her. And then I would have to start the L10 process for a former tenant. And as of September 1st, 2021, landlords can go after former tenants through the landlord and tenant board for unpaid utilities, unpaid rents, and damages. But again, I have to find her in order to start this process. And landlords are time barred. They have 12 months from the date that the tenant moves out in order to do so. And if you miss that limitation period, well, then you miss it. There's nothing that you can do. We're almost at the end of the presentation, guys. I want to take a moment to talk about Bill 60 because we've all heard about Bill 60 coming into effect. Yeah. All right. So I want to talk about Bill 60. Some of this is coming into effect. These amendments are coming into effect on July 1st, and some are coming into effect on September 21st. But the first thing I want to talk about is on the non-payment of rent notice. So the notice that we talked about today, the termination date is going to be reduced from 14 days to 7 days. Number two, on a personal use notice, the N12 notice, if it's being served for the landlord's own use, and if a minimum of 120 days notice is being provided to the tenant, that 1 month's rent compensation is not required to be paid. Number three, the Residential Tenancies Act will now define what is persistent late payment. Number four, all termination notices must be on landlord and tenant board approved forms. Number five, the request for a review period has been shortened from 30 days to 15 days. And last but not least, number six, remember we talked about tenants are allowed to raise issues in accordance with Section 82 as to why they haven't paid the rent? Well, if a tenant wants to raise these issues, they must now pay 50% of the arrears in order for them to be able to raise these issues at a non-payment of rent hearing. So follow us on our Instagram, social media, and when these come into effect, either July 1st or September 21st, we will put out a video and let you guys know.
Request for video.
So a request for reviews, let's say we went through the board process and you weren't able to reasonably participate. Let's say, for example, you didn't receive a notice of hearing. You can file a request for review now within 30 days from receiving the order, basically saying I was not able to attend the hearing for whatever reason. I wasn't notified. I didn't have a key to the mailbox. I was in the hospital. The board will either grant or deny that request. Right now, you can do it for 30 days. It's going to be reduced to 15. So we're coming close to the end of the presentation, guys. If you do have a landlord client who's looking for some legal support, they can go right onto our website, stonegate.legalservices.ca, to book a free consultation or a discovery call with our team. And last but not least, guys, this is our free toolkit for Ontario Realtors. I don't sell anything. I'm always giving away our learning materials absolutely free. If you are listing and selling tenanted properties, scan that QR code. That'll give you access to our Google Drive where you can download this guide and you will have access to a pre-listing checklist, clauses that you can put in your agreement of purchase and sale, scripts, forms, lots of great free stuff from that guide. And here we are at the end of the presentation. I would love to open the floor now for a Q&A.
Yeah, it does not work. I think it's just the cutoff.
Oh,
I think online. Oh yeah, because you guys can't. I'll put it in the WhatsApp group. Is that okay?
mhm.
Okay. You guys can ask your questions.
Bita, what's brewing on that then?
So right now, the act doesn't define what is considered as persistent late payment. What has been working for us is that we tell our clients, if you want to pursue a persistent late payment application, your tenant has to prove, or you have to prove that your tenant has established a pattern of late payments. So 7 late payments in a 12-month rental period. As of July 1st or September 21st, the act will define what is considered persistent late payment. Okay?
So we don't know yet.
Right now, we say 7, minimum of 7.
Oh, God.
Yeah.
6, 7?
6, 7. Yeah. Right.
One more thing on that, they can't make good on the payment at the end of the day and say, if you get a persistent payment.
So let me explain this type of order, or this type of notice yields a pay on time order. And what that means is that tenant has to pay in full and on time in order to void that order for 12 consecutive months. And if they can do that, they void that order.
Is that section 17?
Section 78, you got it.
But I've heard that even building, some people fail on that.
Yep.
And then they can still stay.
So some people fail on that, and then what they do is when the landlord files for order terminating the tenancy in accordance with section 78, the tenant will file a stay of the proceedings, basically to inform the board why they missed the payment.
So another chance. Another chance.
And then it's up to the board. Remember, anytime you go in front of the board, you have no influence. You don't call the shots, you don't make that determination. We don't do that either. It's up to the board what they decide.
So it says it's paying, how many days is considered late? Like just one day? What's a late?
Well, we just mentioned that for
Yeah.
persistent late payment, a minimum of 7. In a 12
7
month.
days though?
No, 7 times.
So, oh, that would be
It's
considered.
rent is late the day after it's due.
Yeah, so
if
one
it's
day.
not paid.
Okay.
Yeah.
I'm gonna ask a hypothetical one on this one. What happens if there's a couple and they live in the house and the husband, they break up, but the husband or the boyfriend's still on the lease, but the girlfriend stops paying. He still comes to the court, not like he's not a guarantor or anything, he's on it. He's
Has he moved
responsible
out?
too? Mhm.
He's moved out.
If the boyfriend has moved out and if there's documentation to say, it's really up to the
But
board
what
to
if they
decide.
don't ever give you like an end?
We
If
didn't,
he-
what if he's not taken off the lease?
Yeah, he's on leave.
But he moved out.
It doesn't matter.
Okay.
It doesn't matter. The lease will continue on a month to month.
But is she
But
still
it-
considered a single mother when it comes to a judge, or is there a participant
That's
as
a good
well
question.
who actually has like a really good job?
That's a good question. That's up to the board.
Okay.
Now, if we have concrete evidence that this person moved out, would you include them on documentation? Why not?
But so that guy's not liable.
It's up to the board.
This board is.
I'm like, is she single still or not? Yeah.
It's up to the board. And the reason why it's up to the board is because you don't have an influence. There's no law that
It's
says
still a contract.
it is still but the board only deals with landlord and tenant matters, not contract disputes. Contract disputes you have to deal with in small claims court.
Oh.
So then in someone claims court, can we go after the husband or ex? All right, Bita, we're going for a ride.
So regarding guarantor. So if you put the name of the guarantor in that lease, that doesn't do it.
No.
Like on that one little line that says
No.
guarantor,
What's
nothing?
the point of
Nothing.
putting the guarantor's name there?
A guarantor, there is no point. A guarantor agreement needs to be a separate agreement. You can't put Caitlin Fulton in brackets on the lease and say she's a guarantor.
Then I guess why do the TREP forms have guarantor?
Yeah.
Yeah.
So is it
Or
TREP
AREA forms.
Or you're wrong.
Because, are you recording?
No, here, wait. I can pause. Pause.
On.
Yeah.
Yeah.
You can. So here's the thing. If you put Caitlin on the lease as a tenant, you can, because occupancy is not a requirement to a tenancy. Here's the but. Remember, so she doesn't have to physically occupy to be a tenant.
Yeah.
That's no different than, let's say, for example, she had children and they were going to McMaster. And she signed a lease for one of the bedrooms on the share housing. She's the person on the lease, but her child is living there and going to school. She doesn't have to live there in order to be a tenant. But when does her obligation come to an end? Is it when the lease goes month to month? Possibly. I'm not giving you a definite answer because it's up to the board to decide. What I'm saying is that if things go down and we go to the landlord and tenant board and she has a representative, the first thing I would say is it's a month-to-month tenancy. Her obligations came to an end in month 12.
Even if he or she is on the.
Absolutely. She can't be responsible for that tenant forever. Contracts are Contracts, the tort of contract law, you must have a start date and an end date.
But even when she's on title, like on a.
Even when she's on title, she has a position at the board. Doesn't mean that the board will remove her. That there would be maybe there's an adjudicator will say, no, I want to keep her on there. Maybe another adjudicator will say, no, we'll take her off. Contract is a month to month.
So this is what all those students down there do, like whatever, like.
Right.
The mom or dad is on the.
Because the students have no money.
Yeah.
So if I'm going to garnish someone's wages, I'm going after her. Mom has money. What am I? The 19-year-old student has no money. That's why they do that. That's why they put mom or dad on the lease. But she has a position at the board, is what I'm saying.
I've got a question for you. I know you do touch on this, but last year I had a lease property that I had to put up for sale, and it's the second one now again. What is your position legally with the tenants asking for 3 months cash for fees?
How much are they asking?
3 months,
Which is how much?
It's 6,000.
12,000.
And then what is the consequence if you don't do a cash for keys?
The landlord said she's not gonna pay because not after $12,000. That's it.
Right, but the landlord wants to sell the property?
Yeah.
And what happens if the landlord sells the property, commits to a firm APS, and she's not able to perform vacant possession?
The tenants were very adamant, they're not gonna,
Okay,
they're not signing any form.
but again, what happens when the landlord commits to an APS? Commits to vacant possession, but is not able to perform vacant possession. They can't perform the contract. They're going to be in breach of contract. They're going to be sued by the buyer. And then they still have the tenant.
What is the landlord's rights there now to sell her properties?
She has two options. She can list the property, which she's doing now, right? And if the buyer wants to move in, they will have to include that in their intention to move in the agreement of purchase and sale. And then once the offer is firm, the landlord would have to commence a personal use proceeding. What you have to know is that there is no guarantee that the board will end the tenancy just because the property is sold. What'll happen is you'll go to a hearing, you'll have to meet the requirements of the N12 notice. But if the board is not satisfied that the buyer requires the property for their own use, they will not end the tenancy. The sale of the property is not relevant to the tenancy. In my opinion, the landlord is going to suffer a lot more than $12,000.
It is actually kind
And
of
so are you. You're the agent, right? So are you. So are you, because you know what? You're the one that they're going to call.
Well, I did take it off because I couldn't guarantee a buyer that they'd get possession. And you're not fast, so
And you lost the listing.
suspended.
Right.
What about the N11 then? Should they agree?
That is the NLF. So the
Okay.
cash for keys would be the NLF.
Should you sign that before you list the property or
So
during?
if you're going to do a cash for keys, first of all, you should never do a cash for keys. You don't really know what you're doing. But a cash for keys includes an N11. That should always be done if the landlord wants to do cash for keys before listing the property. Get those guys out, because I'm telling you,
Should
you're
they
going to
move
suffer.
out too before you
Yeah.
go on the market? Not
Yeah.
put it on.
Don't put it on. What's the point,
Yeah,
right? Just because you sign an N11 doesn't mean that they're going to leave.
it's true.
There's no guarantees.
They give the cash and they still won't leave.
Well, you wouldn't get, like, there's a cash for
I guess
keys
you
is
don't
a
give the cash
process.
until they move out, right?
You would have to give some cash. It depends on how your cash for keys is structured.
And that should be structured by who? Okay.
Right. Our team, our team. Mhm.
The process any quicker, when you sell a property, you give the property notice at the N12. And you do everything correct, and then the day of. That the tenant's supposed to go, the day of the closing remains. Is it any quicker to deal with that if you've done everything properly?
No.
With these-
Cash for keys is quicker.
No, cash for keys.
Here's the secret. The more cash you offer, the quicker they'll leave.
Fair.
But if the tenant is there, now this happens too, it's very common. It's not a requirement. It's the
But they're paying.
alternative to going through the board. The problem is, even if you go to the board on the N12 and you get an order on the N12, you still have to file with the sheriff. It's still going to take time to get them out.
Look at all the, I can tell people have like deals coming
Yeah,
up with
so
all these situations.
In our situation, Bita, should we even put up the property on the market? Or
Wait.
no? Wait.
Wait till they're out.
Wait till we
In
figure
our
out.
situation, also, don't even put it up there.
No.
I have a similar one. She talked to you too, actually.
Wait.
I think we, the three of us have one. I'm
Let me
always looking
tell
at
you
your
why.
question
Oh, yeah,
too.
yeah, tell me.
So whoever's going to be buying this property,
Yeah.
right? Covenants that run with the land continue when the property exchanges title. Okay, that means if I'm buying that property, I'm taking over all this garbage, all this non-payment issue. I'm acquiring this mess. If you get a buyer or buyer agent who calls you and says, hey, do you have any issues with this tenant? And you say, yes, we're actually in the middle of a legal proceeding for non-payment of rent.
Red flag.
Do you think they're going to say, okay, I'm going to bring an offer? Or they're going to look at it?
Well, I'm so charming that they know.
Tenant is cooperative.
Right.
Very cooperative.
Right.
Agent say that, except the tenant only allowed showing Saturdays between 4 and 7.
Very cooperative.
I
Yeah.
don't think this is cooperative.
Yeah, no.
Only 3 hours.
Wait.
Wild.
Because this way, I mean, you have an extra personality. You have an angry tenant. When a tenant is not paying the rent,
Mhm.
they're basically drawing a line in the sand and they're saying, I'm not paying you.
Yeah.
So nobody's going to say, hey, I'm going to put an offer in and I'm going to acquire this. The landlord will be happy because here, take it.
What is a reasonable cash for keys? Is it like 2 months rent, 3
So
months?
we find that anywhere from 10 to 15,000 is enticing
For the tenant?
for the tenant.
So
Could be
much
for
money.
the landlord if it's a really good market, right? Get the tenant out so you can at least sell the.
At least it'll sell better.
Yeah.
Oh.
Nobody buy a best.
So don't give advice. Talk to us.
I love giving advice though.
I know.
I'm really good at it.
Whatever you say, the opposite.
To the opposite of what I said.
Oh, yeah.
Actually, that's
Yeah,
how
fair.
I operate.
You keep everything inside.
They're saying buy
Or the-
commercial instead if you want to
Buy
invest.
commercial.
Get insurance.
By far.
Yeah.
Damn.
15 days, you can keep everything inside. When you start auctioning.
When I serve that certificate, should I put other for myself?
Let Birkin do it. Birkin will do it and then you'll just sign it. Right.
Santa doesn't want to. He's like, so which one do I?
I really want.
Yeah.
I really thought my truck was.
Let's say originally that you go month to month. Is there like what are the pros and cons of signing? Is that something?
Okay.
That's a good question because we've had that last week actually.
There's no pro.
There's no.
There's no pro. Signing a new lease only gives the tenant accommodations for X amount of time. There's no benefit for a landlord to sign a new lease. In fact, lease renewals, you guys know what a lease renewal is? I don't know what a lease renewal is, but every time I turn around, a realtor's like, I have my own lease renewal.
No.
What the hell's that? Don't do that either, right? You
Just
can't
automatic.
make up your own contracts. It doesn't work that way.
What if the tenant wants to do it? Like if they want to do another year?
I think the tenants just not understand that just goes month to month.
Yeah.
When they ask that. I don't know.
For my own rental property, I say, we're not doing that.
We're not.
No.
Nobody's.
Do they think they like it secures the place for the year? Maybe that's
Maybe.
what they think, but
Does it or it doesn't?
It does for the tenant, not for the landlord. There's no benefit for me to have her in the property again for a year. Because if I want to sell it, if a buyer wants to move in, if my kid wants to move
then you're
in,
tied
then
to
I'm-
another.
exactly.
Oh yeah, then you really have to wait.
What if both really want it? Then can I do it?
I think they both just don't understand.
sure.
Yeah, I've done it.
Oh my god. Asking for
better
a
off
friend.
go.
Just month to
This is a
month.
very asking for a friend question.
Any terms and conditions on those? And or does it carry over?
The OG lease carries forward.
Oh.
Carries forward. The only thing that comes to an end is the term, because contracts cannot be indefinite.
But it kind of seems indefinite with a month.
Yeah, but you have to have an
Seems
end
never-ending.
date in it.
Interesting.
It just automatically goes month to month.
Yeah.
Should I give a notice of rent increase during a notice of non-payment?
That depends on what the strategy is. That depends on what the strategy is.
Piss her off.
Yeah. Run that by Burke. Sometimes it's a good,
Scare them.
yeah.
But it scares them.
Sometimes,
To make them like want to move out or
sometimes it's applied pressure, right? So here's the rent you owe us, and oh yeah, by the way, in 90 days. Yeah. But talk to us first.
what was that new thing though? What was that new thing that came into play?
Bill 60?
Yeah, did we talk about that?
Yeah, we talked about Bill 60. The 6 big things coming into effect July 1st and
Oh,
September
July
21st.
1st.
Yeah.
Okay.
Was it Bill 59?
After 1 year's lease ends, the tenant wants to stay, but wants to lower the rent. Should we sign a new lease?
Okay, so this is what's happening. Is very common. That's happening, especially with the downtown condos. It's really up to the landlord. I would not sign a new lease at all. I would offer the tenant a rent abatement, temporary rent abatement. And what that would look like is we're not going to sign any new lease, any rent reduction, rent discount. No, what we're going to do is we're going to do a rebate. So if our lease is $2,000 a month, you pay me $2,000 a month on the 1st, like you normally do. And then on the 5th, I would rebate you 20% for a year.
Oh,
So that means that when I need to increase the rent, I increase it on the $2,000. And then your rent will come back to 2,000 at the end of the rebate period.
so you just do it for a year?
You just do it temporarily. And the reason why is because if many landlords and agents are reducing the rent or trying to offer a discount for a short period of time, but they do it incorrectly.
Yeah.
Or unlawfully. And then later they find when the tenant challenges it, they find that, oh, I've reduced the lawful rent. Then you have an angry client, right? So.
You look at me and I never want to rent with a
Yeah, literally. Tenants requesting, oh wait. Never mind, that was different. They both just asked. Never mind.
Wait, but is there a form for that rebate or just
No.
do an email?
Don't make your own forms. You call us and we will walk you through it.
What about the guarantor agreement? Is there like is there a guarantor agreement somewhere out there?
There's, to my knowledge, no. Guarantor. No.
Oh, Claude.
Clyde. He's
Perplexity?
You're gonna give me a
you
hard
guys
time.
have him?
No, because we don't deal with guarantors.
Okay.
You need to talk to a real estate lawyer who does contracts. Don't put it in Claude and say, pretend to be a real estate lawyer.
So don't like talk them out of being the guarantors, put them on the.
Just put them on the lease.
On the lease as a tenant.
If you're
That's
repping the landlord, I
Yeah.
guess. Doesn't this make you guys want to do lease listings and all that stuff?
It's not to discourage you.
It's scary though.
It
It
is
should
scary.
scare you.
But you need to know what could happen.
Because people take leases very lightly in
Yeah.
this industry, and
Yes.
it's almost more serious
Huge
than a liability.
liability.
To be honest,
Yeah.
That's why I hate double ending.
it's really scary.
Hate it.
Double
It's
ending a lease.
Hate it.
Oh, yeah.
Yeah.
It's the worst feeling.
Do you prefer to rep the tenant or the landlord?
Landlord all day.
Scary
That's who
stuff.
my original contract is with it. Don't like their brother.
But then we've seen those lawsuits where our agent gets sued 2 years after it because of
That's the thing.
non-payment, and
Yeah.
they were paying for 2 years and then stopped, and then they sue us, which is a current.
Which happens all the
It's
time.
the
too.
current thing that Claire's dealing with right now.
Yeah.
Actually,
There's lots of case
Mhm.
law on that, actually.
it's still going on. Isn't that crazy? One of our agents leased out a unit to a tenant. Tenant paid for 2 years, stopped paying all of a sudden, and now the landlord's coming after us and the agent. Like, right? Like it happens.
But there's lots of case law on that, because agents don't properly pre-qualify.
But this was a qualified tenant for 2 years and then
The
just
circumstances,
stopped, right?
right?
For you. When we do the lease as an agent with the arrears, agreement to lease. And then after that, we've got to do
Ontario.
the landlord and tenancy agreement.
Oh, I'm
Ontario
sorry. Oh,
Standard Lease, yeah.
Yeah.
Now, sometimes our agreement has a little more clauses than that one. Can the tenant go after, oh, but we agreed to this on this lease and you didn't have it on this.
So let me comment.
Yeah.
Don't do your own clauses on Form 400. Use the Ontario Standard Lease. It has all of the legit clauses that are required to be in a lease agreement. Don't go making up your own clauses. You don't really know how to craft your own clauses properly.
Well, and the law like overrides.
Section 4 of the
too.
Act, any clause that contradicts the law, even if the parties agree, that clause is automatically void and unenforceable anyways. The reason I say don't do your own clauses is because if your client is under the impression that, yes, I can enforce no pets because the tenant agreed, and then they call you and then you say, well, you can't really. It kind of makes you look incompetent. Why did you put a clause in there that I can't enforce? What was the point of having it in there?
So that's the, did you look at the area standards or did you know, just the.
Ontario Standard Lease.
Like our clauses are pretty much go towards the law. Unless you guys are adding your own, obviously, but I think the ones we use are pretty with the law.
Yeah, it's the $1,000 key deposit for a key that costs $5.
Yeah.
The cleanup fee, damage deposit, these are the
Maintenance.
things that are against the law that
Yeah.
landlords want in, but. Just as long as they know that they're not enforceable, we'll do that sometimes, but you gotta tell them,
Same
it's not
thing.
enforceable, but I'll put it down for you, to make you feel good.
I don't think we have a pet on ours.
No,
We don't put the pets on ours, so if you guys are adding pets, then that's you guys. What's the other one? Checks and stuff like that too. The tenant has
Method of
to
payment.
offer to do checks. If you guys are paying more than 1 month's rent, that's gotta be voluntarily done by the tenant, like, no? What's that one?
No. So we can't
can't, like,
use
have it.
terms like that.
Yeah, that's what I'm saying, like, you
Yeah,
can't use
you
those.
cannot
Yeah.
use them. Yeah, you're right.
Like, some people will put them on, but
No.
there's things that you can't.
So someone wants to pay like a year upfront.
So
So what kind of term we can use? It's
Nothing. They
voluntary.
owe first and last month's rent.
So even if we put down voluntary, the tenant voluntary? Yes.
For law.
So let me ask you this, okay? What is the point of that? What are you trying to accomplish by putting
Well,
tenant agrees to pay 1 year upfront?
someone throw money at me, I'll just take it.
Okay, but what's the point of it?
I think their position is that if they're representing a tenant,
Mhm.
and the tenant doesn't have a very good profile.
Okay.
Bad credit.
Or whatever,
Newcomer.
and now representing,
Yeah.
us representing the tenant, we submit our offer to the landlord, and they're agent saying. That the tenant voluntarily submits an additional
Okay.
6 months rent.
Just to qualify.
Blah, blah, blah.
So what happens in month 13?
Well, then you're back to.
Voluntary, right?
And they usually say to be applied against the 7th, 8th, 9th, and
Yeah.
11th.
Right.
month.
So future deposits are illegal deposits.
All right.
So what happens is, I'll tell you what we're commonly seeing. What happens is because tenants that are in this position, bad credit,
Yeah.
they can't, or they no establishment of credit, they are voluntarily providing these monies to be applied to future deposits. Once they get the key, because there's been a pattern of rejections, they will file an application with the board.
All that.
Right. And do you really want to start a tenancy relationship like that? Having to go through the board to refund this tenant back? You don't. So even if they pay this 1 year in advance, they still have bad credit. They
True.
like, what's gonna happen in month 13?
That's what she's saying.
They still have bad credit. So that is your out. That is your out. If you're looking for a way to reject, that's your out.
Yeah, not necessarily bad credit, but somebody who's only had a job for 6 months.
A newcomer.
somebody who's-
Yeah.
that's
I
land-
feel like I
Yeah.
have a newcomer.
Yeah.
It does, but the law applies to everybody.
So like now I have a client who is a newcomer.
Mhm.
And no credit, nothing, no job. and
Right.
This is how she wants to start her life. So this is what she said, like, I'm gonna pay 1 month. Like, that's
1 year?
1 year?
1 year?
1 year, sorry, 1 year.
Just to make it look
So,
more
yeah, so,
appealing.
okay, you know what,
Mhm.
I have the money in my account,
Mhm.
so instead of paying.
But what she's saying is like, they could be lying too, and then they're just gonna tell you that, and then on month 13, they're like, I'm out, and not pay rent, and then you can't kick them out.
Or you know what else happens? They'll give you the check for a year and then they'll go to the landlord and tenant board. They'll get that money back and then they'll stop paying rent. This is what we see happening. And then you now have to go through this process to get them out.
She can't find a place because she's new, so.
You gotta almost work with like professional property management companies too. Like my guys will never accept more than 2 months rent. They'll accept tenants like that, but
The apartment buildings, the small landlord will ask for this. But the
big
actual
guys.
big
That's what I'm saying,
guys,
for the big property management, yeah.
Yeah.
But
They
a mom and
won't.
pop landlord, no.
right?
Do the big guys get their hearings quicker than
No.
everybody else? Cause they
No.
take everybody on regardless almost.
They do.
It's the same.
The same.
It's the same process.
They got their own like
The
paralegal.
board doesn't discriminate for the number of rental units.
Yeah, they got their own like
If
paralegals.
if you ask me, I think that the board should allow smaller landlords to have their matters heard
Quicker, yeah.
than bigger landlords.
Exactly. Actually, yeah, that makes sense.
Should we start
A movement?
Yeah, let's start a petition. Get the,
what happens if, that ex-husband has left the house, and there's a new.
yeah, what if there's a new
new husband?
boyfriend?
Yeah, is he liable for anything, or he's
He
allowed?
lives
to
there.
He's an occupant.
Does he have to pay rent?
Occupants are not protected by the act. They're not tenants. Unless they've been acknowledged as a tenant.
So how do I acknowledge that he's a tenant?
Like if his car's in the driveway every day and you
You're
take a
not gonna be
photo.
allowed to do anything without consulting me first. They are. So what is an acknowledgement? So you're taking direction from me. Hey, Sanak, there's a leak in the sink. I need you to come and fix it. And then you say, okay, I'm gonna come and fix it. Or I send you the rent and then you accept it. This is all acknowledgement of.
I gotta convince him to send.
So it's almost like impossible to sell a place with the tenant in it and they are not cooperating in showing or whatever.
It's not impossible. Nothing's impossible.
Like
It depends on which route you want to move forward with. If you're going through the landlord and tenant board, then you have to list and sell the property. Like there are requirements that you have to meet first in order to go through the board. If you do cash for keys and you flip them some money, maybe they'll be open to that.
Because the bigger problem is that we just can't guarantee vacant possession.
That's right.
Period.
Period.
Ever.
Oh,
On it, especially on a tenanted property.
But if I give them cash to key and the closing is afterwards to make sure they leave.
I think
then it
she's
should be
saying no.
okay.
I think she said to avoid that almost.
Yeah, so you don't do this because you don't know what you're doing. Cash for keys should be, it's a process,
Oh,
right? So we want them out first before you list the property.
oh.
So that
even
the
list.
even, and let me tell you why, because then you're not going to have any problems with access to the property. You're not going to have any problems with the feedback.
You'll
Oh,
sell it
that's
more.
disgusting. It's, yeah, I can't get in. There's no lockbox. You're going to avoid all of that. And then you can guarantee vacant possession because it's already vacant.
You probably get a higher sale price too.
There you go.
Yeah, I have this tenant lived there for 15 years.
Right.
So, you know, if we just follow what's allowed to increase the rent is like, you know, it's not even up to date.
Right.
Can we get her out with this
Cash for keys.
cash to key?
So here's the problem with long-term tenancies. Oftentimes tenants want a lot more money. And that's because their rent is low now. So anywhere they go, it's going to be. So I'll give you an example. Yesterday, I got off the phone with an agent who said that I have a client who has a tenant who's renting a whole house and they haven't paid since 2016.
Huh?
Holy
2016, 10 years of non-payment. This person, I'm not going to say who. I'm going to get to that. This person is in a high paying position. This person is in the media. This tenant is in the media. And they have been renting an entire house in the West End of Toronto for $600 a month.
Is she a real estate agent?
No,
600.
$600 a month.
Oh,
So over the last 10 years is what? Less than $20,000 that she owes.
And then what happened?
Well, we're just getting retained for that. So going through the landlord and tenant board, maybe we'll get an order, but because of her position, she might pay it. My point is, because her rent is $600, how much would you offer her for cash for keys?
Yeah. For 10 years not paying.
20,000 would not be enough. Where's she gonna go to rent a house in Toronto for $600?
he's a roommate. A lot of roommates.
A lot of roommates.
Wow.
Is it how
You're
they
representing the landlord?
We're repping the
calculated?
landlord.
You only do landlord.
We only rep landlords. No
Okay, what
tenants.
happens if you increase or you send the notice to increase rent and the tenant's like, no, but I'm
Okay.
also not leaving.
Right, so it's a notice for rent increase. It's not a we agree to rent increase the rent. No, you have 90 days. You either pay the increase or you get out. And if you don't pay, and if you don't get out, and when the rent becomes due, if you don't pay that increase, I have no choice but to file with the landlord and tenant board for non-payment of rent.
Interesting.
But you talk to me first. You're not allowed to do anything anymore. Thank you.
For that difference, like, which is like a $25, for example,
Right.
and then, okay.
But you're not going to the board for just that difference. You're going to the board for the difference for X amount of time, future amount of time.
Even for future.
Absolutely. That's what the rent is. The rent was increased. You didn't pay the $25 increase. So if I don't go after it now, if you don't raise the rent every year annually, you can't go back retroactively and say, well, I didn't raise it for the last 5 years. I'm going to do all 5 years now. You use it or lose it. So if you don't go after them through the board for the $25 for future rents, then your rent goes back less than $25.
Yeah, this might be out of your area of expertise, but for the cash for keys settlements, do you know if the landlord can write those off as a deduction from when they sell their investment properties? So like you write off.
It would be
real estate fees,
yeah.
you know?
You would have to talk to an accountant,
Massively.
likely because it's an expense. But you would have to,
It's a write-off.
you would have
That's a
to,
write-off.
That's my area. That's my area of expertise here in Osu.
We don't let you do anything in real estate with no.
Yeah.
You're gonna have to do something in.
Accounting.
No way.
Oh, no.
and accounting.
Accounting too.
I'm surprised they still have you here.
Me too.
Talk to Claire.
Yeah, right.
That's why there's not hearing.
Oh, right.
There's not here.
Kate, you kind of had a question too. Do you want me to? Do you want to ask your question? I know you're a little more shy, but you had an interesting one. Not really, but something to do with a garden suite.
Yeah. There is an accessory unit on the property that was not permitted when it was built.
It was not.
It doesn't
Permitted.
permit.
Ooh.
It's a double garage on the bottom, there's a unit on the top.
Mm-hmm.
He's been trying to get permits, it's been rejected. And she has an open application right now.
Landlord?
He's asking, yes, if he should just rip it down before listing it.
But there's a tenant in it, right?
Yeah.
Okay.
There's no problems with the tenant. They're paying their good tenants. But he's asking if he should just take it down first or try to see if somebody wants to continue with the application.
How's he gonna get the tenant out?
That's the other question I had more for you too.
Yeah.
Was can
Well,
you like it?
Okay, so tearing it down is totally separate issue than having it tenanted.
Yeah, I'm more like the tenant.
Yeah, I'm more worried about tearing it down that's the easy part.
Sure.
Mhm.
How are you gonna get the tenant out?
Yeah, he hasn't spoken to them about, they seem to have a good relationship as far as I know.
For now.
Right.
Do they follow the same rules of
He has
accessories?
Yes.
Okay.
He's like thinking, hoping it might go by fall.
Does the tenant know that it's not? Okay.
I don't know.
We're doing wild things out there.
And you're not involved.
Is that crazy?
I know. Okay, so there's two separate issues. Keep them separate. But he would have to first deal with the tenant issue before he does anything else.
Would you try finding someone to over it with the tenants over there?
Well, here's the problem. You're gonna have to disclose that that's not a legal structure.
Buyer's good thing.
Yeah. And then now what you're trying to do is find that buyer to legalize that structure and say, hey, by the way, it's tenanted.
Yeah.
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 Well, Peter's also perfect.
Get the tools out, everybody stops.
I didn't tell you to do that. It's up to the landlord. But you're gonna have to deal with you should deal with the tenant issue first. Because you can't do anything else if they're there.
So, I do not like to take any clients that are looking for a basement.
Okay.
And I have one now, just kind of a friend. And, so we're going through these basements and they're like horrible. And I'm sure that they're like, all of them are not.
Illegal.
Like, yeah. So I really don't know how to deal with that because I know they're all on a MLS.
MLS, yeah.
They put it there. And I find like there's tons of them.
Mm-hmm.
Some of them looks good. Some of them like you go inside, like you smell like mold like that.
Yeah.
So if we sign something and that tenant goes and like say, okay,
Complaints.
I'm in this basement and the
Mhm.
basement is not legally like.
So
permitted.
legalization of the unit or the property is not mentioned in the act. Those two are two separate things. That's
Okay.
why I said for this lady here, they're two separate things. The law, the Residential Tenancies Act, does not require a unit to be legal. It requires that unit
Okay.
to be safe.
So it's nothing coming after an agent? Like,
Well, anyone can come after the
The
agent.
difference between legal and safe.
Like
Legal means you have permits.
Yeah.
yeah.
Safe means it has a smoke detector, carbon monoxide detector, two means of egress,
so it just has to be to code, not
to code,
legal.
not legal.
I don't know about the rules on MLS.
So
but-
can you just put these things in a contract? Like,
No.
okay. Like a
You can't just
landlord
put
must
stuff
put
in a
it-
contract and think you release yourself from liability.
You just say,
No,
no, go and work
no.
for Tim Hortons is safe.
Yeah.
Well, you'll make less money,
Probably say, right?
right? But yeah, you can't just put them in a contract and think because they knew about it, I wash my hands clean. Doesn't work that way.
Like it's stuff like, okay, the landlord must put, I don't know, smoke detector, like stuff like that. Can we put them there at least?
You could, but the landlord should have a smoke detector. That is the minimum.
It's like a legal, I think it's like a fire code.
Minimum.
Like,
Well, they would come probably after the landlord.
landlord.
Or the.
But the landlord can come after you
But then
because there's
Or
case
your tenant
law.
could also come
Right.
to you.
What if you
It's
talk
very
to-
serious working with tenants.
No. So this is a good question. So
Oh, nice.
What's your
very good
question?
question. He said, what if I drop off the smoke detector and say,
Amazon.
oh,
yeah,
no.
yeah.
You have to send a guy, right?
Yeah.
And say, go, put this up,
Yeah.
test it, make sure the tenant can see the green light, and it's been tested and documented. It has to
But
be
you
working. You
don't-
have to make sure the unit is safe.
That's not our, like, she says we're gonna get the whole thing ourselves. I said, like, no, we can do it. And then the landlord says, why did you just put that smoke detector in my basement? We can't do that.
Well, it's protect yourself.
I mean-
$50, you get your own. Fucking.
I'm not going to say, Santa, go and install this. I'm gonna say, go send a guy so that he's not liable, because if it comes to him, he's gonna say, I sent a guy, I sent Nelson. He's my fire guy. I don't know, whatever.
I can install it.
We need to talk to Claire.
Know about this one.
But thank you so much, guys. I'll take
Thank you.
one last question here.
Agents not vetting tenants properly.
Mhm.
So is there a specific list and does like the landlord have grounds?
You have a list.
And how do you, what are like best practices to document like date properly?
That is a great question. I have to come back for a pre-qualifying prospective tenant
Yeah.
session where we talk about a combination of the modern and traditional screening tools. But there's a list. If you go on to
I think you have one in your files somewhere.
Landlord Mastery downloadable guide that we have, landlordmastery.ca, there should be a downloadable guide, but I'd be happy to come back for that
Okay.
presentation. If it's okay with you guys, can we take a quick selfie?
Yeah.
Yeah?
Oh, Claire's here.
Whoa,
The
big boss.
big boss man is here.
He's got all his questions.
Good morning. You just missed all of the wonderful questions.
So I started at 11.
Well,
Your son, your son
Fired.
is not fired. He's doing really good.
we need to talk about your son.
He's fired. Hey, how do we squeeze on it?
Can we all squeeze in
Just
here?
listen to you guys on it.
Oh,
Always
let's see.
There we go.
Oh, where are we? I think I can see your yellow.
Oh, my yellow.
I can see you.
Awesome.
Thank you
All
so
right,
much.
guys. Thank you guys so much.
The question.
Okay, on mine.
Who's gonna do a lease now forever?
Yeah. No more leases. See you guys soon.